Good morning. Happy Wednesday. It's hump day. And the Annunciation of the Theotokos, which means I get to have fish today. It's been a long Lent. My diet prior to Lent was meat, eggs, cheese. Because I'm low carb, high fat. And since Lent, it's been almonds, or almonds, as it's appropriately said, and oysters. Not the most fun diet ever. So I am looking forward to fish today. So that's not what you came here for. First of all, on Decastro versus Doe, he's suing a bunch of Nevada Highway Patrol officers whose name he doesn't know. He hasn't been able to serve them yet because he hasn't been able to identify them yet. He asked for an extension of time. Out of curiosity, I looked at his... he's also asking for the court to permit discovery from the Nevada Highway Patrol. And I thought that's weird because the Nevada Highway Patrol is not a named defendant. They're not a party to it. I guess you could get a subpoena, but all the cases that he cited in support of his request for an extension for time to serve and the request for the discovery dealt with getting discovery from known named defendants who had been served, getting discovery from them to find out who the Doe defendants were. Not entirely sure that his argument is going to carry a lot of weight. He is pro per, so the court might give him more time. At some point, though, the court is just going to dismiss it without prejudice. Obviously, since there was never a named party, how could you dismiss it with prejudice? And he'll have to get the names before he files next time. I guess he could just file again for Doe defendants, but he's going to run into the same situation. Out of curiosity, I looked at his declaration, his supporting declaration, to see what steps he had taken. And apparently he only took one step, and that one step was submitting a public records request to the Nevada Highway Patrol, asking for a lengthy litany of categories of documents and videos and things to be produced. Many of which I think the Highway Patrol wouldn't issue, but he asked for them. He also asked for a fee waiver under, I'm going to see if I can remember this, having not looked at it since about 2 o'clock this morning, something like Nevada Revised Statute 239.055, which no longer exists. That statute, whatever it was, I mean, you could still find it online, but it's been repealed. So I don't know why he would ask for a fee waiver under a repealed statute. Maybe he's just using ChatGPT to prepare these things. But he said basically, if it costs more than $50, let me know ahead of time, if you're not going to grant the fee waiver. And my best guess is that because he's asked for so much under his FOIA request from November of 2025 and done nothing since, it's going to cost a lot of money. My best understanding of the public records laws in Nevada is that if it's going to take more than 2 hours for them to compile and prepare and research to get the documents, they get to charge the actual cost. So if they're paying somebody, $25 an hour or whatever they're paying them to sit down and do the research and, redact the videos, because they probably will, et cetera, then it is highly likely that he's going to be looking at the hundreds, if not thousands of dollars, because this is going to be a project. And since he submitted it in November, and he doesn't have the records yet, I would assume that either they've denied it or he didn't submit it to the right place. You can put a submission online. You don't even have to write a letter like he did. You can just submit it online. So either they denied it, or they don't have the records that he's requesting, which is unlikely, or they responded and said, here's your fee to do it. And instead of paying the fee, he's now trying to maybe get the court to do a subpoena to them to get the information that he wants. We'll see how that works. He is pro per. The court might grant him a little bit of leeway on time to file. He's already asked for discovery before, if I remember correctly, and they've already turned him down. So we'll see. Again, it's a nonsense case, but it's kind of fun to go along for the ride. In DMA versus Fraud or Troll, Cordova versus Hinault. People don't like it when I say Hinault, so I say Hinault. I think it's like Hinault, but it's Hinault. I'm American. I speak Americanese. Randall S. Newman, Captain Charisma, filed his opposition to the motion for dismissal pursuant to the forum nonconvenience doctrine and for a bond. And obviously I agree with everything he said about the forum nonconvenience. It just never made sense. I understand why they want to do it, but it never made sense. So nothing Randy said changed my mind on that. I still think it was a loser of an argument. I understand why they did it procedurally. It's going to muck things up. There's winning the lottery chances of getting what you want. You never know. Maybe they'll win, but very unlikely. On the bond one, though, I didn't know a lot because I don't do copyright law, and I don't really follow this case very closely. I just look at interesting things that interest me in it, and the motion to dismiss for forum nonconvenience and the bond issue was interesting to me because I know about those. So it'd be interesting to see the way it shakes out. But Randy made excellent arguments, as far as I can tell, that he's very unlikely to succeed on the bond issue. And after Randy laid out his arguments, I was giving it like a 50-50 shot before. Depends on what Randy says, but now that I'm looking at the arguments Randy's making, Randy made excellent arguments. Excellent arguments. For example, the spoliation issue goes directly towards their likelihood of success on the merits. Because apparently, in discovery, they haven't turned over not a single... That was a lot of dings. Not a single video. Not a single video. They asked for all the videos. They didn't turn over a single one. Speaking of which, Fraud or Troll asked me to review the videos in his declaration. And I told him, I don't think it's likely the court is going to even look at those videos. The court will read your declaration, but I seriously doubt the court will look at the videos. Randy objected to those videos, first of all, because they were clips and they were taken out of context, and it would be more misleading than helpful. And second, because Fraud or Troll didn't provide even those videos in the request for discovery. And now you're going to say, well, they're available on YouTube. Why do you need them through discovery? Because you're entitled to them through discovery. That's why. Because you ask for specific things and they give you back the things that you ask for. And then they say, this is everything responsive to that request. This is everything that I have responsive to that request. I don't have some things anymore because of X, Y, and Z or whatever. But they basically, you ask for categories of documents, videos, whatever. And you say, I want all the documents in this category. And they make a representation that they're giving you all, some, or none of them. And why they aren't giving you the ones they're not giving you. And that essentially is useful at trial, because then they can't pull a video out of their ass to present to the court at trial, because they didn't disclose that to you. They didn't give that to you in discovery. And so you can say, I object, Your Honor. Like, they said they gave me all the things relevant to this, and now they're presenting something new. So it is not just a formality. There are ramifications down the road on what you produce and what you don't produce at discovery. Again, if he says, I want all the videos that you made relating to or regarding or discussing fraud or troll. I don't have his request for production in front of me, so I don't know how he phrased it. And fraud or troll produces, all your videos relating or discussing DMA. And fraud or troll doesn't produce any videos, then you can move to exclude any videos that would address fraud or troll, or address DMA from fraud or troll at trial. This is not just a formality. This has ramifications that go to trial. And by not producing the videos, it really makes me think that Lou, the attorney for fraud or troll, who I am misnaming on purpose, that Lou isn't preparing for trial, because I think Lou's competent. Lou's shown competency. And this is like if you don't produce the videos in discovery or in your initial disclosures, if you don't produce the videos, you can't use them at trial. And Randy is making an excellent point. They didn't produce these videos in discovery, and yet they want to use them to support their declaration, to support their motion. I'm objecting to it on that basis. I think the court's going to take that seriously. So when fraud or troll asked me to watch those videos, I didn't, because I don't think the court is going to review them, and I still don't think the court is going to review them. Especially now that Randy was smart enough to make the objection. But in the request for admissions, which is like, if he changes his story, I mean, you could show the request for admission to the judge. I guess they agreed. I think originally they asked for a jury trial, but I guess the parties have agreed that it's going to be a bench trial. So there's not going to be a jury. So all the people were hoping that the videos were going to bias the jury against Cordova. No, you're just going to have a judge. And I am 90+% sure that judge is not going to get biased. I mean, these judges deal with hardened criminals, people who do heinous things. Somebody being a jackass in public and filming it isn't going to bias the judge. It's just not. Like, if it was like a 50-50 thing, it might tilt it slightly and give a person the edge. But in the grand scheme of things, you're not going to bias the judge with Cordova acting like a jackass in public, which I assume he does. I don't watch his videos. So he's admitted to spoliation, essentially, by deleting the 1,700 videos. It is likely that the court will find that he deleted them because they contained fraud or trolls or Cordova's copyrighted materials, and it wasn't fair use. I'm not saying the court will, but there's a high likelihood that the court will find that you deleted the videos, you didn't keep copies. He says he didn't keep copies of them. Bad news, Bears. There's a high likelihood the court's going to infer that those videos contained copyrighted material that was not fair use. And I guess Randy found some third party who archived the fraud or troll videos from DMA. And so he now has a list of 67 videos. So, I mean, it is looking worse and worse for fraud or troll. And I'm not giving him legal advice. He has an attorney. But in my estimation, it is going to be in fraud or troll's best interest to settle this matter. I don't think fraud or troll really wants to go to trial. Not as set out in the declaration by Newman with the attached response to request for admissions. It is not looking good. It's bad news bears for Fraud or Troll. And I know Fraud or Troll fans don't want to hear that. I'm sorry. I'm sorry. Not my fault. I'm sorry. That's the way the facts are shaking out. That's what I'm seeing. I'm seeing most likely, almost certainly, he's going to lose on the form nonconvenience. Most likely, he's going to lose on the bond issue. Most likely. Because of the spoliation, there is a high likelihood that at trial, there's going to be an inference that he deleted these videos because they contain copyrighted material and because it was not fair use. Which means he would lose on all the deleted videos. He would lose. Bad news bears. As far as the consent is concerned, Fraud or Troll asserted that he had written consent from YouTube comments written allegedly by DMA, and he had verbal consent by a comment made on a video by DMA. That's contested. I know you want to believe that what DMA did amounted to consent, but you might be wondering why an attorney, Randall, who, despite what you think about him, is a competent attorney. He's competent. Despite what you think of him. You might wonder why Randy is saying that no, it's not sufficient consent. It's not like they had a contract. It's not like they had a written agreement prepared by an attorney setting forth the parameters of this whole, I'm giving you permission to use my stuff. Oh, and the nonsense about Cordova not having the copyright anymore. Apparently Cordova formed a LLC, Executive Lens. And Cordova appears to be the sole shareholder in it. Maybe he has another partner. He might have a partner in Randy. Who knows? I don't. But he appears to be the managing partner of it because the transfer agreement of the copyright from Cordova to Executive Lens is signed by Cordova, both as the person transferring the copyright and as the managing member of the LLC. And it clearly allows Cordova to retain the right to sue for copyright infringements while Cordova had the copyrights. So, I mean, all the arguments that have been presented by Lou sounded good, but aren't bearing up to scrutiny. And I entirely agree with Randy's assertion that Lou didn't set out the facts appropriately and apply the facts to the law appropriately. He made a lot of legal assertions. He made a lot of factual assertions that are basically just we have these defenses and things like that. And he did not do a proper breakdown of what the facts are, how the law applies to those facts in this instance. So if I had to bet on it at this point, not seeing the reply from Lou, which is probably too late to fix what he didn't do in his original moving papers, but without seeing that, at this point, I'm saying 99% sure that the form nonconvenience goes and about 80% sure that the bond goes. So there you go. Also, as just an aside, my most stupid commenter managed to get under my skin yesterday, and I want to apologize to him and to everyone else who enjoys my comment section, but I hit him, and it's my fault that I hit him, And he's going to stay hidden until I can unhide him without getting irritated from him. I don't want to have hate in my heart. And the best way for me to avoid that is just hiding his comments. I will unhide his comments sooner or later. But right now, he just got under my skin. I don't like disingenuous people. I really don't like disingenuous, stupid people who misinterpret what I say on purpose to make a straw man, a caricature of what my position is. I'm very blunt about my position on Israel, i.e., I don't fucking care about them. Like, they can exist, they can not exist. I don't fucking care. Like, I don't care if they defend themselves. I don't care if they attack their neighbors. I don't care if they take land. I just don't care. I just don't want them to use American blood and treasure to do it. I guess that makes me an anti-Semite. I don't know. I don't care about China. I don't care about the U.S. hegemony over the world. I don't care about it. I care about the only thing on the geopolitical sphere that I care about is the U.S. and its prosperity and the well-being of its citizens. That's it. If there's some bad person running a country in Timbuktu nowhere, I don't care. Not my problem. If Iran is threatening Israel, don't care. Not my problem. If Israel's threatening Iran, don't care. Not my problem. I do care that Trump got us involved in Iran. I care about that because that directly affects the U.S., our prosperity, our blood, our treasure. It directly affects that. So that's why I care about Iran, not because I like Iran. I don't care about Iran. I literally don't care about Iran. I'm not an Iran aficionado or supporter. I'm not rooting for Iran. I'm rooting for the U.S. to get out of this war with as few losses of troops as possible and as little money spent as possible. And if that means giving up our bases in the Middle East, I don't care, because I don't want a world empire. I want us to focus on us and stop spending our money overseas and stop sending our youth off to wars to fight and die for nothing. Nothing that benefits us anyway. Anyway, rant over. Thanks for watching. Have a great day.